This is ridiculous. Your witness list has grown by 2/3. And I don't know why. You better have a dang good explanation, because if you don't, I'm going to exclude it.
The Young Thug YSL RICO trial got heated today. Judge Glanville gets annoyed with the state for continuing to add discovery and witnesses this late into the trial, stalling motions that need to be heard and blindsiding the defense lawyers. Yeah, this one gets pretty wild. The judge like literally yells. It's towards the end of this video. If you're new, mention you'll subscribe. Let's get right into it. All right, first off, we got Thugger Daily tweet right here. Co-defendant plea deal accepted. Durante Bebby has accepted a plea deal in the YSL RICO case less than a month before trial. He rejected one in 2022 in December, which carried a 6-year sentence. If he accepted it, we were down to 6 defendants. He accepted 5 years in jail and 10 years probation. He will still get credit for time served. You know, he's probably going to be in there for another like 3 or 4 years or something like that.
Sir, I'm going to oppose that motion for this honorable court to announce that this witness or this topic goes to Overt Act 177, for example, as Ms. Hilton said, or the prosecution being able to announce that to the jury for the following reasons. There are witnesses in this case that I will cross-examine, that it will transcend any overt acts, will go into other counts of the indictment. I have nothing to do with count 1, which is the RICO conspiracy. This court will not let me, I will not do it and say, now Mr. Witness or Ms. Witness, I'm now going to refer to, count number 58, wrongly charging Mr. Williams with whatever. That is not appropriate. I objected to this when this came up before this honorable court said. I said it's just like giving another opening statement. Okay, now this is what we're focused on. The jurors have to take this as a totality of the case, weigh everybody's credibility, and they're not pigeonholed into one item. So I am objecting. Okay. This is also not that complicated of a case. I don't know where 3 months comes from, 3 to 4 months. I can't imagine that it's a 3 to 4 month case unless the court grants our motion to get rid of 300 plus witnesses and the discovery that was served and thrust upon us, including today, by the way. There's some additional discovery, believe it or not.
There was more discovery today. What has the state attorney's office been doing for the past year? I mean, they've had this case like brewing since May 2022. Why haven't they already given all the discovery to the defense? That's like crazy to me.
It's a long case, but that's what notes are for, and that's what they're charged to do. This is an FBI cell phone, cell site, historic cell site supposed expert. And he looks at the January 10th cell phone records for certain parties. He excluded from the draft report, I have a draft report, by the way. I don't even have a final report. He excluded certain cell phone records that we have for that day. He then looks at the March 2022 shooting involving Mr. Drinks. He doesn't exclude any of the cell phone records he gets on that date.
Yeah, I mean, Brian Steele's doing a good job. You're witnessing a lawyer find out that an expert was excluding little details about cell phone records of different shootings. So now he's picking that hole, of course.
And in the other analysis, you have these same cell phone records. This is the entire global of cell phone records. But in Donovan Thomas, you did not analyze these. I want you to explain to the jurors who told you not to, why you didn't do it, and why did you not put Jeffrey Williams' information in there? I can't find any case that allows a court to do that.
Mr. Hilton, Mr. Uhelski, I'll take that under advisement. You can kind of supplement for me. I now see the challenges the defense it may have, and it may pose some problems. Your suggestion. So,
Mr. Steelwell right here, by the way, boys. This guy was arrested in the middle of a goat sacrifice. Yes, you heard me correctly. Apparently, when he was arrested, there were goats and blood present. Attorneys for Thug filed a motion claiming co-defendant Shannon Stillwell, who is facing numerous charges including murder, was arrested by police while in the midst of a religious ceremony which involves supposed sacrifice of goats. Should that be told to the jurors? Probably not, because it's an immediate L. But, I don't know, dude. I'm not a judge. I can't rule on that. What are we listening to, dude? Oh, there's Thug right here. First time seeing him today. Got a cardigan and a red tie on.
Gotcha. Okay. All right. No problem. Thanks, Aaron. Appreciate it. Oh, and another thing? And testing. So we can do a driver.
You can tell he likes his lawyer. I always see him laughing with his lawyer, so happy with the way his lawyer's been representing him.
This discovery is just full of hearsay upon hearsay upon hearsay, and it would be impossible to particularize every piece of that.
Bro's defendant's just sleeping next to him while he's fighting for his life.
If the state is going to say that I'm going to have to become a witness, the jury is sworn. Mr. Stillwell contacted me. You know who really contacted me was Kara Convery, who used to work in the DA's office. I wrote them a letter. I said, I don't represent Mr. Stillwell. I don't know what jail calls are, but to put in front of this jury that Mr. Stillwell asked or wanted Mr. Williams to pay for me, he never paid for me, ever, to represent Mr. Stillwell, ever. And now, to throw that in, that is somehow going to be relevant in the case, and I'm going to sit there and look like I'm the...
Oh, so the guy who apparently was sacrificing goats, the state is trying to say that Young Thug was willing to offer to pay for Brian Steele to represent Shannon Stillwell. But Brian Steele is saying no, that didn't happen. I remember he put a motion in to not let the jury find out that he represented anyone else, because I think he represented someone like years ago in a murder trial, like 10 years ago, who was a co-defendant that's probably not even on the case anymore.
I'm some sort of lawyer for Mr. Williams to hire for other persons in this case. I asked about that a long time ago when we had the motion to have me removed from the case.
But I did tell you that it might become that part of the challenge that you individually as counsel are going to face is that potentially there might be an actual or a perceived conflict. And I said that could be revisited.
Do you know when those calls were made?
No, I don't.
Well, let me tell you. Well before May 9th of 2022. That's before Mr. Williams was arrested. So you're telling me today the state has more evidence that it didn't have in August 21 of 2023 when we argued this motion? That's not accurate. And if they're just reviewing their evidence, that's pitiful.
Your Honor, we've had this evidence. It was turned over. Matter of fact, Your Honor, a portion of this evidence was already submitted during a motions hearing involving Mr. Viverito, specifically the calls regarding Mr. Stillwell when we went to go seek his cell phone out, Your Honor. So this is not new evidence that the state is reviewing, and that is why we asked the court to hold on his ruling, because we knew we had additional evidence of Mr. Steele or Mr. Stillwell requesting Mr. Steele.
I got a phone call. I denied representation. I never went to see Mr. Stillwell at any jail. I doubt I even said I'd come down to see him at a jail, but whatever's on recording. I wasn't on vacation. I haven't taken a vacation. I'm working, and it's preposterous. I've never been retained ever by Mr. Williams to represent Mr. Stillwell.
Who do you believe in this situation? It sounds like the lawyer is telling the truth and that the prosecution has just a few details of a recording where it sounded like Stillwell maybe called Steele panicking and got advice from him, but he wasn't officially his lawyer. But I can't tell.
And so what am I going to do now? So what am I supposed to do now? So this comes in, so I have to testify before the jury and explain how countless people give me the honor of calling me or emailing me or texting me and asking me to represent, and I politely say no. I mean, do you realize that you're giving the state all this time? They don't perfect their motions. They don't give us the notice that you're supposed to give us on co-conspirators, supposed hearsay. They're not giving us discovery. They give us discovery today. I mean, do you realize what as lawyers we're doing here?
Bro is just baffled. Do you realize the state is fucking us in the ass by giving us discovery and adding witnesses when the trial is basically starting?
The indictment purported lyrics of his published music and social media poetry, and the use of these lyrics, poetry, artistry against Mr. Williams.
Oh, the lyrics. Oh, the lyrics coming up. Okay, bet. Here we go.
Would be a constitutional violation. So
we're arguing that.
I'm sorry.
We argue that. You said next Wednesday, the 8th.
Yeah, we'll take that up on Wednesday, the 8th of.
The text messages that may come into evidence, or Instagram, or Twitter, or lyrics.
Text message conversation on Labor Day 2020, Mr. Huey and Mr. Williams states, "Slatty, handle, and stay very low" means that somehow there's going to be a physical attack on Mr. Bennett, aka wife and Lucy. Is that right?
Well, that was an example.
Oh, they're bringing up the wife and Lucci shit. Okay. Wait, what did Thug say? Let me go back, bro.
Slatty, handle, and stay very low means that somehow there's going to be
Slatty, handle, and stay very low. Man, Thug created his own damn language.
Term. It's not a gang term. It's used actually in the case by several officers in recordings that we have. And slatty handle, the jurors will hear what slatty is referred to a lot by a lot of people, and the word handle is self-explained. So I just use an example, but there's several, and we don't need to sit here and have a witness who's the court may or may not say is an expert to say, well, let me tell you what slatty means and what slatty handle means. And in this particular circumstance, this is exactly what they were saying, because that goes to the intent of the writer, speaker, and it's the same for the lyrics.
The state's response is that this attempt to exclude testimony is kind of improperly mischaracterizing opinions, whether lay or expert, as mind reading. There's no case law supporting that position. Instead, you have the state is entitled to offer opinions about the meaning.
Mr. Yeltsin, let me stop you just for 1 second. Are you going to have some particular expert, one of your experts, tell what these particular terms mean? Or, I mean, I don't know what slatty handle means or stay very low is, but then again, I'm not on Instagram or these other social media sites for me to understand that.
Correct.
So who is going to come in here and testify or elucidation about that?
Gang experts such as
No.
Miss Viverito.
Judge, you've got to.
And if I could just respond,
interrupt you. I apologize.
If I could just finish the response.
Let him finish, Mr. And then Mr. You can respond.
Expert testimony about gang jargon that talks about coded language that is going to be beyond the average juror's understanding.
This is like what happened on the Melly trial. They had that guy come up with a mask who talked about all the shit he knew about gangs, but then it came out that he never actually even infiltrated a gang himself, researched the terms of gangs, which I thought was kind of bullshit in that trial. This trial's a little different because it is like a gang charge. It's a RICO charge, like a gang charge. So it kind of makes sense for them to bring some sort of expert to explain some of these terms. So low-key, I kind of agree with the prosecution here. Someone could try to decipher it, but it's like slatty handle could mean a lot of things. It doesn't necessarily mean go kill someone or go stab them. Like, I'm pretty sure YF and Lucci got stabbed in jail or whatever. So it's just really iffy. I get both sides, basically.
And it is helpful to the jurors because they don't know what this stuff means.
How can you...
Well, okay, are you finished, sir?
I am. Thank
Okay,
you.
all right. Now, Mr. Steele, what does he want to tell me?
First of all, how do we defend this? I've asked, it's in writing for a year. What is the background? What is the import of the gang supposed expert's testimony? I don't have anything. We have no reports. I get a CV. Now some gang expert or some lay witness.
He should have full reports by now. Full fucking reports of what this gang expert is going to talk about at trial, dude. Why is this not already done? We're a year in. What is the state attorney's office doing? Year and a half into this shit. The trial's starting at the end of the month. Why doesn't the defense counsel have full reports of each expert yet?
In addition, you've
And
heard...
unfortunately, for a gang expert, it's not like a scientific witness where you get a report. You get a CV, and the person's going to, if they qualify, will tell us the basis for their knowledge on this.
You
So-
ordered under 704, 24-7-704 under Harris versus State.
The judge just said that it's not like you're going to get a report because it's a gang expert.
You ordered already that every gang expert, in fairness and preparation for cross-examination, give the background of what they specifically what they're going to testify and how they get there. I have nothing. It's been ignored. Your orders go ignored by the state of Georgia's prosecution team. In addition to that, we've argued this. You deferred it, and you would make a decision. If it doesn't help the jurors, you can't use a lay witness or a fact witness. If the jurors get it, they don't need
It's
some.
slang. I mean, and it may, and what, I mean, there's a lot of slang that we have in our language, but whether or not it's the average layperson understands it, I mean,
That's what you said before. You already ruled on this. You defer it.
depending upon who's qualified, would in fact help the jury. I think it would be.
Maybe. It depends on the circumstance, right?
Yeah, but I think it would help the jury. So I'd probably allow that. But what was the other thing that you,
See, I had a feeling he was going to allow the guy to explain the slang terms because to the average person, they don't know what the fuck that shit means.
please don't come in here and say, you know, we didn't really look and update this transcript and it needs to be done, and I got a jury sitting in the box. That's what I don't want to have happen. So if you all have gotten if you all got recordings that you have updated,
Judge is starting to get annoyed with the state right here. Doesn't want them suddenly saying they have to update transcripts or something.
There are certain transcripts that were done. I will state to Your Honor that there are hundreds of discrepancies in each transcript that exist, in my estimation. So, and that includes the ones that were done by words expressed, because you have to understand, Your Honor, that these people who work for these companies are listening to this without any context. I can certainly understand what individuals are saying and referring to, and it's much different that's on the transcripts, and that includes the words expressed transcript.
I think the way to handle that, folks, is short of it being you all agreeing upon it, because I'll just let them listen to the tape, listen to the audio for themselves.
People are saying thug, and it's written down as Doug, okay? There's names that are wrong, there's references that are wrong, there's places that are wrong. It's a mess.
Serves us or the state with the information, it comes back with how to read the information. They call it a legend or a key. I was not provided that, so I don't know. I'm guessing, but I don't know if this is UTC time. I don't know if this is Eastern Standard Time.
This is the same thing that happened in the Melly trial with the phone records having confusing times and like the cell towers. Like, say me and my friend were in this room together, my phone could ping a different cell tower than his. So it's just a complete clusterfuck of cell tower data that's just like annoying as shit.
Numerous times I know we're going to argue, but I should have had all this. This was done in 2016. I mean, I'm getting it in September 29th of 2023. I also spoke with a witness.
Been on the search and on the hunt to look for this particular affidavit. Investigator Crabtree, who was the affiant of the warrant, we've been in communication with him. He's no longer with the office. We've been trying to go through and get access to his email account to see if
Oh, so you lost the affidavit. Period. End of story. It shouldn't be in the court case, dude. Your state attorney's office and you lost it. One of your fucking employees moved on and left the office, so you lost it. Take the L.
we are able to get this affidavit. We're not sure. We have tried speaking with anyone he may have served it to. We've looked through all the documents in our office to see if there was a physical copy of the affidavit, and at this time we have been unsuccessful.
Discovery, they had this for years. I got this.
Okay,
in
bottom line up
September.
front. Bottom line up front. What do you want?
I want this is why I'm in such a bad shape. I thought I was ready for trial, and I keep getting this discovery. I want all discovery from discovery 12 to 13
They're
to be
saying they
excluded.
don't have it. That's what they're saying. So what's the remedy for me? What are you asking me to do?
Well, let me ask you this.
No.
I understand.
No.
I'm
Answer
asking
my question. What are you asking me to do?
I'm totally answering your question. But let me show you this. I didn't know about this till September 29, 2023. I'd like you to consider why didn't I get this when discovery was due 10 days prior to January 4th of 2020? And that is really my basis. At this point, I'm asking you to just do a bright line rule. There is no discovery the state can use and no witnesses after discovery 12 and in September of 2023. And this is what I'm dealing with. So I'm supposed to go out and interview the person. I don't even know what we're talking about, and I don't know why I'm getting it on a report from May 7th of 2015 today. I mean, not today, September 29th.
That's crazy.
Okay.
8 years later, they're getting a report.
Okay, so
I want to exclude it. I don't want to deal with it. I'm trying to make this more manageable for everybody. I just don't, unless it's exculpatory, why am I running down Gary Baker's report now?
And so what I need to do is confirm that this May 7th report is not a part of those items that had previously been served up to June of 2022. So we will know that answer indefinitely by November 16th. So we are asking to hear this on November 16th so that we can, one, confirm that this report wasn't already previously served.
Let's assume it was not previously served.
it hasn't been served, I'm going to exclude it. I'm going to tell you that right now. If it has not been served in 1 through 12 already, I'm going to exclude it.
Well, we would ask for the court to hear us out and hear our argument on, because we have briefed this issue and we filed a brief as relates to exclusion of evidence, Your Honor. And so we would ask for you to wait until November 16th so we have our argument, because we have briefed the issue and we would like to be heard.
I'm hearing it right
At
now.
some point in time,
Your Honor,
at some point in time, I have to draw a line, and the state's got to be ready with all this stuff. It's just an issue of fairness as well.
Your Honor, and I believe that
I'm telling you right now, Ms. Hilton, if you haven't disclosed it already, if it's 1 in 12, and it's not exculpatory, it's gone.
Your Honor, we would ask, because we would ask that all of this be reserved for the.
Oh, he is pissed, dude. Here we go.
All came up in September. You said you allowed us to.
I am really annoyed about this, Ms. Hilton. I just am. This is ridiculous. Your witness list has grown by 2/3 since then. And I don't know why. You better have a dang good explanation on the 16th, because if you don't, I'm going to exclude it. Okay. But right now I'm telling you, without anything further, it's gone.
Well, we would like to
Exclude a lot more on that date, because this is ridiculous. There is no plausible explanation I've gotten and that would suffice, that we just kind of keep, you keep dripping and driving out evidence.
Well, we'll be asked to be heard on the 16th, Your Honor. We'll have all the explanations for the court.
I'm telling you, it better be a good explanation, and if it's not, I'm going to exclude it. I'm just going to tell you that right now, because
I wonder what their explanation is going to be. I mean, you're filing shit. This specific situation, 7 years old, 8 years old. Like, what are we doing here? The trial is starting, boys.
you all have also dragged the court along in terms of, I've asked Ms. Hilton, not Ms. Hilton, I've asked Ms. Love several times to tell me why it is that it's taken so long. And the explanation I get is, we have duplicates, okay? I don't doubt that there's probably some duplicates, but I still have an issue with why your witness list has grown, almost doubled. I mean, I just do. And can you explain that to me at this point in time, Ms. Hilton?
Your Honor, the state's witness list has not grown. All of the witnesses that are on the compiled list are in the discovery. And we have case law to say so long as that they're in the discovery, the state does not have to provide a consolidated witness list. Every witness was in discovery in a police report or in some other type of report.
But shouldn't it be fair enough for you to fucking like tell them your official witness list like way beforehand? Just because they're in discovery, whatever case law they're referring to is not fair.
The idea that we provided a whole bunch of new names is just not true. And so we will further explain this with the relevant case law on the 16th. All of this is inside of our motion. That is not the case.
That is the case.
Okay, well, listen, if you haven't
Thug's lawyer said, that is the case.
disclosed this, and I'm telling you right now, in 1 through 12 already, it's not otherwise in there, but any documents that you've already supposedly given in discovery, I'm going to exclude it. I'm going to exclude it. If it's a duplicate and you can show the court and counsel here that, yeah, we gave that to you in discovery dump 3, and it was in there, then that's, I don't have an issue with that. Because I do agree that as an advocate, you do need to search your own discovery and whatever. All right, anybody else? I see you all at 9:30 on Monday, okay? All right, we're in recess.
Thank you, Your Honor. Have a good weekend.
Thank you.
Hold up. What was bro just doing? I gotta go back.
Anybody else? I see you all at 9:30 on Monday, okay? All right, we're in recess.
Thank you, Your Honor. Have a good weekend.
Thank you.
Oh, he looked right at the camera. He did that for the camera. He's acted right now, bro. What was that?